submission. My client, he suffers from, okay. His wife also has a device which helps him hear too. Now it's one.
Okay, will that work for you, sir? Or will that work for you?
It's a little better. Yeah.
It's okay. That's
it. It's not. We're amplifying it a little bit more, but it's better.
But will it work for you, or you want the other device? Whichever one. You want the one your wife has, or you want this one?
Let's do this.
That one? Okay, very good.
Thank you.
The honor, today is the date and time set for the probable cause conference. We will respectfully be requesting that a preliminary examination date be set.
Discovery is complete.
To the best of our knowledge, Your Honor.
People have their witnesses available.
All right, pause for just a second. This is where things get real. A preliminary examination is basically the test run for the prosecution. Can they actually prove enough to move forward? Think of it as the legal filter. Weak cases get tossed, strong cases head to trial. What do you think? Should more cases be stopped right here before they waste everyone's time?
Laura Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Abbott.
Bond will continue.
All right. Thank you.
Thank you.
Much.
Thank you, sir. Court does call the case of the people versus James Chapman.
Alexander on behalf of the people.
Brian Bowling on behalf of Mr. Chapman.
Thanks.
State your name for the record, James.
James Chapman.
Judge, we're here for a PCC today. I'm asking that this matter be set for an exam, and I believe all discovery to be complete.
We just motion for dismiss.
Pipe dream, but yeah, that'd be nice.
Bless you. Would people have their witnesses available the 23rd?
We'll do our best, Your Honor.
Preliminary examination in person will be set September 23rd, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you.
Judge Barr.
Court does call the case people versus Tanisha Aikens.
Legal. Simpson Public Defender and Apple appearing on behalf of Ms. Aikens. No.
Aikens, will you state your name for the record?
Tanisha Aikens.
Thank you.
Your Honor, we're asking for an adjournment for some continued plea negotiations.
Probable cause conference will be adjourned to September 25th, 2025, 9 a.m. Bound continue.
Okay, thank you.
Okay.
Court calls the case of the people versus Curtis Damon.
Your Honor, the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Damon. Mr. Damon, state your name for the record.
Curtis Mitchell Damon.
Thank you, sir.
Your Honor, regarding the probable cause comments, we're asking for a preliminary examination date. I would like to address bond, and there's also a bond violation to address as well.
Yeah.
It's a little bit old. I think it's from early August, late July.
Well, let's get your preliminary examination set. What was the subject?
A positive scram.
So right now he's sitting here with no bond.
Correct, yes.
Okay. Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 23rd?
Yes, Your Honor.
All right. I'll set preliminary examination September 23rd, 2025, 9 a.m. before Judge Freshour. Okay, go ahead. I have it in front of me now. From June 25th.
June?
That's the one I have. Well, yeah. August 12th, I'm sorry.
Okay.
Enrollment date was June 25th. I'm sorry.
Okay.
August 12th.
Just want to make sure I was coming from the right headspace. So I did have a chance to speak with Mr. Damon regarding the violation. He is going to admit to the violation today for the positive drug or the positive alcohol result, he did, for the court's information and I guess bond, relates bond as well, he did complete 30 days at Sacred Heart inpatient treatment. He got out and essentially relapsed. Right after that relapse, he had a mental health crisis and was hospitalized at the hospital.
Health source.
Health Saginaw. I did speak with his fiance, who's a social worker for Salvation Army, and she did provide me with all the information. He was petitioned by the court for hospitalization due to suicidal ideation. He completed, I think, 12 days there in an inpatient psychiatric hospital, and that's why he missed his last probable cause conference date that was scheduled for August 7th. There was also the warrant in place that was kept in place. So given all that, Mr. Damon obviously has been through a lot over the last couple of weeks. He is back into compliance with his mental health treatment. He's on new medication, and I also verified this with his fiance that is really helping and has changed his disposition. New medication that he wasn't on before. He's also on abuse, thank you. And they referred him to AA, NA, and a support group, which he's been attending since leaving the Saginaw Hospital. So given all that, I think Mr. Damon is on the right track. He was fully honest with me about his relapse, and is really ready to get out, get his life back together, and stay sober. He's now has over a month sober, so we're asking for his release.
How long has he been in? Okay, go ahead.
Now here's the emotional punch. This defendant just came out of treatment, relapsed, had a mental health crisis, and is now claiming he's back on track. But here's the million-dollar question for you. Should courts show compassion and give second chances? Or is public safety too big of a risk? Drop your thoughts in the comments. I'm curious what side you're on.
Working, and I don't know what else we can do other than keeping him in custody at this time in order to ensure that he continues not to drink and continues to remain sober. I have some concerns given that the underlying facts in this case involve his drinking as well. The report indicates he also had some warrants out related to some alcohol offenses at the time. He was threatening to harm another individual, was being rowdy, and obviously resisting police officers due to his intoxication. So I just have concerns given this pattern of drinking, especially while on bond, his inability to control his drinking, that if this court were to release him, that he would just continue drinking and violating them.
I think things have changed. I think Mr. Damon admitted he relapsed in late July.
Here's what I'm going to do. I'm going to get through preliminary examination to his violation. I'm going to sentence him to 30 days, credit 10, the balance he's to serve. And then this will be before Judge Freshour can take a fresh look at it at that point in time. All right. Thank you.
Thank you.
What does call the case of the people versus Philip Barnhart?
Actually, both for the people in both matters.
Assistant Public Defender Ben Dunaway on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
The court receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check ex-jail, and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. It's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested, and those.
What?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, well, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine.
I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones. And he's still, I don't know that he should be out because at some point, luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I would absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. We don't know if this is a one-time slip-up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond? I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his VAC was incredibly high. And I'm going to double check that before I get that search to the court. But if I recall correctly,
Whoa, did you catch that? A blood alcohol content over 0.30. For context, 0.08 is the legal limit, and at 0.30, doctors say you're flirting with death. The fact that this man was still out in public is jaw-dropping. Imagine if he got behind the wheel. Should judges be setting higher bonds in cases like this? Or is the defense right that testing and treatment is enough?
Because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. The court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for, preliminary examination?
No, he's going to waive.
He's waiving? All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. Sir, you're waiving your right to preliminary examination in these cases? Yes, sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution? Yes, sir. People also waive their right.
we waive, Your Honor. I do believe he previously posted $25,000.
Oh, on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
It might be PRs, maybe $25,000 PRs, but
I have each of these that they're PR.
Oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination having been waived, defendant's bound over to circuit court on a single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with the time.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may. What was that date again?
24th, Your Honor.
Court does call the case of the people versus David Davis.
Defender Hannah Apple appearing on behalf of Mr. Davis, who's approaching now. Mr. Davis, will you state your name for the record?
David Davis. Thank you.
Your Honor, we are asking for an adjournment, and then I did wish to address bond on behalf of Mr. Davis.
Basis for the adjournment.
The adjournment, partially as part of the bond argument, but that he can begin treatment at Dawn Farms, which he has set up to begin next week. I'm sorry, tomorrow.
Inpatient.
It is an outpatient program. He revoked his bond last week for the positive test. He is willing to acknowledge that positive test. He did contact Dawn Farms before coming to court last week, completed the initial intake, and is scheduled for his assessment to begin outpatient treatment tomorrow at noon. Based on that and his admission to the cocaine and THC use, I'm asking the court to consider reinstating his personal bond so he can attend that appointment. I did provide verification to opposing counsel last week, a letter from the treatment provider and information regarding, of course, I think based on that assessment tomorrow is going to determine what level of care he's going to be needing. But I advised him that, I'd ask the court to order that he comply with whatever they recommend, if it's regular outpatient, intensive outpatient, or even inpatient treatment. And he's willing to do just that.
I would need is there any response from the people on that?
Your Honor, this is Mr. David Davis, correct?
Yes.
Trevor Mayville for the people. When the case was called, my office had some confusion as to what his first name was and who the case that was being called. So I wanted to enter my appearance for the record. Normally, it seems we don't get in the way of release to treatment orders, but this doesn't appear to be what defense counsel is requesting. This is a felony high violence blood alcohol level being north of 0.18. He also had active metabolites for THC and cocaine in his system. He was given a relatively low cash or surety bond and asked to submit to testing. And in the 3 weeks that followed his release, he was positive for both THC and cocaine in all 3 tests. And that's what was the basis for his bond revocation. I would not oppose a release to treatment, but I'm concerned about his narcotics usage if not done so.
Judge, I don't believe that statement is correct regarding the cocaine use. He had 2 positive tests for cocaine, which were shortly after his arraignment. He tested the next day, and then he did test, I think roughly about a week later, and there was a positive test for cocaine and THC. And he acknowledges that.
That powerful cocaine that's lasting a long time, like the last case. Go ahead, I'm sorry. That was just me.
Yeah, I'm not going to make that argument for this case, but however, he did have a negative test for cocaine. There was still THC in his system. He reports that he has stopped use. He reports that since being incarcerated, he's also made contacts to try to work out a medical marijuana card upon his release. He will not use until that card is received and provided to community corrections. If the court allows.
I get it, but he shouldn't be using it all. He's got serious issues. And the very fact that he wants...
I mean, I think that's between him and his provider regarding the medical marijuana, but I think it's noteworthy that he had a negative for cocaine. He's been incarcerated for a week. He set up treatment. He has it scheduled to begin tomorrow. I would just ask, based on all of that, he is also on a scram tether. I understand the basis of part of the OWI is obviously BAC. There was no issue regarding alcohol consumption on bond. He still has a scram tether on. I don't think that's been of any issue, and he's doing everything he can to show the court that he's compliant and willing to work that out. And he's been in custody the last week. He, I would say fairly from our conversations, has very much learned his lesson and understands if there's even the slightest slip up that he's going to be back in here and he's not going to have a chance to get out. But I would just ask for the opportunity so that he can keep his treatment appointment tomorrow that he's scheduled. And
all right, here's what I'm going to do. I'm going to need an order. I'll allow him to go to Dawn Farm, but prior to him going, I realize he's got a scram tether. He's going to have a GPS tether on his other leg, because if he leaves that program, doesn't cooperate in that program, he's going right back in.
Understood.
So I'll need an order.
Okay, I will prepare that today.
All right, thank you. What is it?
It's going to put you
Hold on. And I return this out to the 25th of Bible continues with that modification.
just until I get the order to the court and they can put that out. Hopefully today.
Court calls the case of the people versus Douglas Brown. That's all I have. So, I don't like the way these are put up. So what?
Douglas Brown.
Douglas Brown.
Oh, I'm sorry. He's on Zoom. My apologies. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Brown. Mr. Brown, will you state your name for the record?
Ms. Brown, sorry.
Thank you.
Your Honor, we are asking the court to consider a very brief adjournment of 1 week. Mr. Brown is retaining counsel. There's been communication regarding Mr. Vincent's office, and I spoke with Amanda
Are they going to
today.
enter their appearance?
They plan to file that all today. The appearance and the substitution.
Did you talk to Mr. Vincent?
No, I talked to Amanda.
Okay, then I'll believe it.
Okay.
Thank you.
You just need a week?
That's it.
So you, my condolences to your family, first of all. And secondly, though, you guys sent him here alone last week. So I don't know what?
As you can understand why I had to.
No, I understand why, but yeah, I don't know I can't remember what he did.
I'm sure he messed it up.
Oh, he did, but I just don't know what day.
We do have a matter in front of you next week on the 18th. So it most likely was that.
That was, so just so you know what he said. Just so you know what he said. He walks in and I said, "You're here alone." He said, "Yeah." I said, "Okay, so what dates did they give you?" He said, "They just said set any date." I don't think that's what you said. That's okay. But if,
And that's how I know that you know me, Your Honor.
yes, I know. You would have given him a date and he would have, well, anyway. All right, I will on this one, if it's gonna retain, then I'll adjourn it out 1 week.
Thank you, Judge.
Go with the other 135. September 18, 2025, 9 a.m. on continue. All right. Thank you, Mr. Douglas. Court calls the case, People versus Ishmael Davis.
Assistant Public Defender Dodger Lee on behalf of Mr. Davis, who's approaching.
Your name, sir?
Ishmael Alexander Davis.
Thank you.
And Your Honor, I do have a green sheet, or I will be retrieving one in a moment, but we're going to be requesting an adjournment order to continue negotiations. We're hoping to wrap some additional cases into a global resolution in this matter.
September 25th, 2025, 9 a.m. File and continue. Court calls the case of the People versus Elia Bellows.
Trevor Maybell on behalf of the people.
Yes, I thought.